Welcome back to BTN Live. Rick Pizzo with you as we continue our coverage on the Gopher football team boycott. Now we look at the perspective from the legal possibilities of what could happen to both the university and the players. To help us do that, we bring in Larry DiNardo, former Notre Dame All-American, longtime partner at Jones Day, and attorney who has a very prominent resume, have argued successfully in front of the U.S. Supreme Court. Larry, let's start with the fact that this is a Title IX investigation being conducted by the university. How does that affect the rights as it relates to the players?
Yeah, so these Title IX investigations are much different than an investigation that the police authorities or state prosecutors would conduct, and that's a result of Department of Education guidelines that were issued in 2011. So some of the fundamental principles and rights that an accused would have in an investigation by the police authorities and the state's attorney or the prosecutors just don't exist. And there have been a lot of people look at these rules and have concluded, and when I say people, I'm talking about experts from Harvard Law School to Stanford Law School, they have all concluded that we've put at risk sort of fundamental fairness and due process for these accused.
Larry, what course of action do you think we should expect from the university over the next couple of days?
So the university, of course, is in a difficult position. They're trying to operate, as I said, under these Department of Education guidelines, which many believe are unconstitutional, deprive accused of their rights. They're trying to do it because, of course, the Department of Education administers funds, a great deal of money, to these universities. So they have that pressure. On the other hand, these students do have a due process right. They are entitled to fundamental fairness. So the university is going to have to figure out, how do they walk that line? How do they deal with the government regulators, who many believe have overreached here, while at the same time not violating the rights of these students? Because these students will have their rights regardless of the guidelines issued by the Department of Education. So I suspect the university will try to find a way to balance these competing concerns, satisfy the Department of Education while still allowing these students to be heard and to present evidence and to test these allegations against them.
Now, the four players who were originally accused never saw charges filed against them. 6 additional players have now been added to the investigation. Let's play a slightly hypothetical game here, Larry. Could the university face any type of legal issue if any or all of those players are found not guilty of any of these allegations?
Well, whether or not found guilty or not, if these student athletes are punished, and as I understand it, some have already been suspended or recommended that they be suspended, others expelled, those students will have the right to challenge those actions in court against the university. The university cannot simply defend themselves by saying we follow Department of Education guidelines if those guidelines are not themselves lawful. So the university, as we've seen in other university cases, will be required to demonstrate that they provided the due process rights and the fairness to these students that, as I said, are not necessarily protected under these Department of Education guidelines that direct these investigations.
Now, on the other side, Larry, the players reportedly met with one of their representatives basically all day today. What can the representatives of those players rely on from a legal perspective in the quest to see the 10 suspended players reinstated, or to get some type of information, some more clarification from the university?
So the timing here is going to be so difficult because they can possibly seek relief in a federal court, immediate relief for denial of their rights, and try to be reinstated. At the same time, courts are reluctant to interfere in any sort of emergency basis. In other words, in a hurry, to make hurried decisions when they involve educational institutions. But that's not to say that the rights of these students will simply go away or not be aired in a court. But my question or concern for them would be, how quickly can that be done? Their rights will be aired. They'll have an opportunity to convince an unbiased court that they were not treated fairly. Whether it can happen quickly enough or not is more problematic.
Larry DiNardo, partner at Jones Day, helping us make some sense of the legal perspective of the Gopher story developing as we speak. Larry, truly appreciate you taking some time today.
Oh, thanks very much, Rick.